Second day in the matter of having taken by Martina Dillon, John McEvoy, Brigid Hughes and Lynda McManus for judicial review.
Lord Wolfson.
Good morning, my lords. My clients are grateful for the permission to intervene in this matter and for the also the permission to make written submissions which you will have received, and these short oral submissions. In the hour we have, we're going to try and save a little bit of time if we can. We would like to cover 2 points. First, by way of shorthand, we call the ECHR reconciliation exception point. And secondly, we also have the victims directive point. And with the court's permission, we propose that I will address the court on the first point. My learned junior, Mr. Dinsmore, will make our submissions on the second point, if that's convenient for the court. Given that I've got limited time on my feet, I wasn't going to spend time at the start addressing the question raised at some length, I have to say, by the respondents, as to whether we have permission to argue what we want to argue. That was in fact clearly set out in my respectful submission in our application to intervene, for which we obtained permission. If necessary, I'll address that point as I make my submissions. But I can confirm right at the start, we are not seeking to overturn or even disturb any factual finding made by the learned judge on the evidence, and which the Court of Appeal said he was entitled to make. We do say, with respect, that the Court needs to look carefully at what actual findings the judge did make, and we also say that the correct legal test doesn't involve or cut across those factual findings. But insofar as the respondents are concerned that we are trying to go behind the factual findings of the judge, I can assuage those concerns because we are not. Turning therefore substantively to the first point, the ECHR reconciliation exception, let me start with a few points which I hope are common ground. First, we agree that there is a general positive duty on states with regard to both Article 2 and Article 3. Nothing we say is intended to diminish that established duty where it arises and where it exists. Second, no matter how strongly or how often that established duty is expressed, it does not follow that there is not or cannot be an exception for cases of amnesties legislated by states in the context of reconciliation following conflict. And there is such an exception, as I will seek to demonstrate in a moment. Third, and importantly, there is a broad margin of appreciation afforded to the state as to how reconciliation is best achieved. Indeed, we submit that this is a paradigm area where there ought to be a margin of appreciation, and a pretty generous margin at that. And further, I might add, the conflict we are dealing with in this case might be said to be a paradigm case of where the reconciliation exception would apply if it exists. Now, the margin of appreciation is especially important here because we submit the question of whether reconciliation should be attempted, and if so, how it might be attempted or achieved, are ultimately intensely political questions. The margin of appreciation is needed to ensure that democratic politics can play its proper role in resolving those controversial disputes. And it is not respectfully the role of the law to give the answer as to what will, and I underline the word will, which is essentially a predictive question, what will be the way to achieve reconciliation, nor, we submit, is it the role of the law to constrain politics from a full and proper exploration of that answer. Now, that means, we submit, that there are 2 questions, therefore, which this court should grapple with. First, is there a reconciliation exception? Does it exist? And I'll add to that, if I may, the other point as well, which was touched on by Sir James yesterday, and I'll get to that. Second, assuming it does, or given the other point, it does for the purposes of this court, and bearing in mind that this is an, I was going to say ex ante, everybody else seems to be saying ab ante, but whatever it is, ab ante challenge, can the conditional immunities fall within it? So those are the two questions. Is there an exception? And if there is, can the conditional immunities fall within it? First question, does the reconciliation exception exist? Our primary submission is that it does. And essentially for the reasons given in our written case at paragraphs 18 and 19. And given the time, I haven't got the time to go through those paragraphs in detail. The court will not expect me to anyway. But we do say with respect, I'll stop saying with respect, please take it as read from here on, but we do say that the critical error that the learned judge made was in relying on the general run of Article 2 and Article 3 cases to conclude that the rule as to the positive obligations imposed by those articles was strict, and that, therefore, the conditional immunities necessarily fell foul of it. The problem is the therefore, because we submit that the judge did not pay any proper attention. He does quote the cases, and I'll come to what he says in a moment, but the judge doesn't pay proper attention to the reconciliation exception cases, which we've set out in our written case. And likewise, the Court of Appeal, we've dealt with this between our paragraphs 19.2 to 19.7, similarly didn't focus on the reconciliation exception and only restated the general principle that breaches of Articles 2 and 3 should not go unpunished. In parentheses, of course, as the Court would have appreciated, the Court's treatment of this issue is necessarily brief because by that stage the Secretary of State had made what they call the concession, and therefore the Court of Appeal doesn't really deal with this point in any detail in its judgment. The much greater detail is to be found on the point I'm addressing this court on in the learned judge's judgment. Second, we submit, as far as the reconciliation exception is concerned, we've set out 4 propositions in paragraph 16, and I'll mention them in a moment. But let me add, if I may, a 5th, and I add this, which I think is common ground, just to clear a point away so we can identify what's actually in dispute. We accept that there is a strong positive obligation on the state to investigate allegations of unlawful killing and torture and degrading and inhuman treatment. That is not in dispute. But the 4 propositions are set out in our written case at 16. First, the pursuit of reconciliation is a clear and recognised exception. Second, the exception is not limited to Article 2, but also extends to Article 3. Third is the margin of appreciation point. And fourth is the fact that the margin of appreciation in this area is particularly important. Now, I'm only going to say, given the time, something about the first point, because it seems to us actually that the last 3 points are not actually disputed, having read the respondent's case. The focus appears to be on that first point. So the first point, whether pursuit of reconciliation is a recognised exception to the positive obligations under the ECHR. Now, we've set out a number of cases, authorities on that in writing. They're at paragraph 16.1 of my written case. Again, I'm afraid I don't have time to go to them all orally, but I know the court will have looked at them. But I will go directly, if I may, to Margus, because it seems to us that that is a useful place, perhaps the most useful place, to look at this issue. And Margus is at 9573 in the electronic bundle. It's a fairly recent case of the Grand Chamber. It's May 2014. And we've set out the facts of Margus in writing, so I'm not going to repeat them. It's another one of the cases which comes out of the Yugoslav conflict. And there is no dispute, if I invite the court to turn to paragraph 127 of the judgment, which is at page 9627. I'm not going to read it out, but there is no dispute that paragraph 127 states the general positive obligations of the state where Articles 2 and 3 are concerned. And what the Grand Chamber then does, under a little heading at 129, the position under international law, is that it says that we need to take into account developments in international law in this area. And then there's a long excursus on developments in international law between paragraphs 129 and 138, which, again, I haven't got time, I'm afraid, to go through now orally. But having undertaken that analysis at 9629, under the heading "The Court's Conclusion," the Court lands, we submit, on the point of principle in 139, which we submit expressly recognises that amnesties are possible where there are some particular circumstances such as reconciliation. Now, true it is, the Court is saying it doesn't apply on these facts. I accept that. But when one looks at 127, then goes through the international law analysis and comes to 139, we submit that the correct reading of 139 is that the Court is saying that there are circumstances, there are reconciliation cases where an amnesty would not violate the otherwise general rule for Articles 2 and 3. Now, as I say, it appears to be common ground that the exception doesn't arise on the facts of the case. The respondents make this point in their paragraph 26 in the document responding to my submissions, because on the facts of the case it concerned war crimes and the amnesty didn't extend to war crimes anyway. But that has no bearing on whether the exception exists in other cases that are not concerned with war crimes. Now, can I just use that as a jumping off point to make one other point, to deal with one other point which the respondents make. The respondents also challenge the conditional immunities here on the basis that they say there's no exception, there's no carve-out for war crimes. Now, I accept that if you trawl through the Strasbourg cases, there is a theme in some of the Strasbourg cases that even if there is a reconciliation exception, there may be some sorts of crimes which, even in the context of a reconciliation exception, could not be covered by an amnesty. For the purposes of this hearing, because it's an ab ante challenge, in my respectful submission, the Court doesn't need to resolve that point, because it certainly isn't the case, picking up the points made yesterday, that in all or almost all cases we can be sure that there will be those, the facts will be such. So I wouldn't want it to be thought that my reconciliation exception is necessarily going to cover every single case. There may be cases, I underline may, where even if there is a reconciliation exception, the facts would still require that Article 2 and Article 3 are applied and the reconciliation exception would not apply.
Might torture be such a case?
It might be. I mean, torture is mentioned in some of the authorities, absolutely. And the problem with some of these authorities, if I may say respectfully, is that quite a lot of them actually are what we would call obiter, because there's a lot of discussion when it doesn't actually rise on the facts. But there is a line, with respect, yes, there is a line in the authorities that war crimes or torture. Now, of course, one has to be a little bit careful when one uses the word torture, because, of course, torture in the Torture Convention is not necessarily torture in Article 3, and torture in Article 3 has now been very broadly applied. So I wouldn't want what I say now to prejudice any submissions made in the future. But if I may say respectfully, I agree with the thrust of the point that my Lord is putting to me.
Thank you.
Now,
I'm just thinking aloud, but I mean, most civilian jurisdictions have time bars for prosecutions, but they don't time bar crimes that would fall within the scope of a torture convention or the or crimes against humanity. But otherwise, there is a time bar, and if one simply introduced a time bar, it's difficult to see, even if it were retroactive, it's difficult to see there would be a convention objection to that. There would be no breach of Article 7, certainly.
Yeah. I mean, there are a number of analogies which we can look at in this area. I always have the words of one Court of Appeal judge ringing in my ear when I made an argument by analogy. He said that the problem with analogies is that they're different, which is the point with which I'm still struggling. But there are useful analogies to be made in this area, and limitation, in my respectful suspicion, may well be one of them. But the carve-out, just to pick up that point, the carve-out from the limitation bar for example, torture, would support, respectful submission, the point my Lord Jones was putting to me earlier. Now, again, just looking at the time.
Just looking at the Belfast agreement, that was an agreement between all the political parties in Northern Ireland except for one.
Yeah.
Two sovereign states. It was subject to referenda, both north and south of the border. So it has the amnesties which were contained in it had unimpeachable democratic credentials. Does that have any impact?
Well,
does insofar as there is an exception for reconciliation, is there any case law as to the procedure that should be adopted in order to arrive at such a reconciliation process?
I haven't seen any case law which says the procedure to be adopted, save that, in my respectful submission, it comes back to my margin of appreciation point. I mean, the fact is no two conflicts are the same, and no two reconciliation processes are the same. And to pick up the point which the learned judge appeared to rely on, that political parties in Northern Ireland didn't much like the reconciliation process put in place by the Act. Well, again, this may drift into politics, but that might actually show it's quite a good reconciliation process if nobody really likes it. I mean, maybe that's the nature of a reconciliation process. One might also add that, of course, it's not always the case that what I was going to say Northern Ireland is probably a point of more general application. What politicians say in public is necessarily what they say in private as well. I probably shouldn't say much more about that last point. But the margin of appreciation point is a very important point. And one would certainly hope that when Strasbourg would look at reconciliation, they would give that a very significant margin of appreciation. Now, I just want to make a point as quickly as I can, although it's somewhat of a technical point, about the number of judges, when one actually crunches through Margus, who support the broad statement of principle. Now, I'm afraid this does get a little complex, and given the time, I'm only going to be able to give the court the references, but the detail is set out in my footnote 32. Paragraph 139, we submit, recognises the exception. And with apologies to the learned judges for making a hash of their names, when one crunches through the independent judgments, the separate judgments given at the end of the case, and there are several, we submit that this is where you get to. 6 judges explicitly reject the notion of an absolute prohibition on immunities in their separate judgments. That's Judges Sekuta, Wojciech and Vehabovic, that's at 9640, and Zimele, Bero-Lefebvre and Caracas, which is at 9634-5. 3 judges disassociate themselves from any conclusions on Articles 2 and 3, noting that, and I quote, the applicability of the procedural obligations stemming from Article 2 and 3 of the Convention seems far from obvious to us in this case. That's Judges Spielman, Power, Ford and Neuberger. That's at 9632. Judge Vucinic notes that the grant of an amnesty for breach of grave breaches of fundamental human rights, my Lord's point, if I may say, is against the increasing tendency of international law in this area, but he doesn't discuss the reconciliation exception in the non-fundamental breaches. That's at 9642. Judge Dedov, at 9643, agrees with the majority on amnesties against grave human rights breaches, but also is silent on the reconciliation exception. Now, where do we get to after that? Where we get to is this, we submit. None of the 11 separate judgments rejects the reconciliation exception, with 6 actively warning against such a conclusion. And as such, even given the majority judgment on the result is a breach of Article 4, Protocol 7, there is no majority support in my submission for the elimination of the reconciliation exception. By contrast, on our reading of the Grand Chamber judgment, i.e. it does recognise the reconciliation exception, that is a conclusion which was assented to by 12 judges, being the 6 that gives the main judgment, plus Judges Secuto, Wojciech, Verhebovic, Zimele, Barrola-Fevre and Caracas, with 5 judges, Spielman, Power, Ford, Neuberger, Vinicic and Dedov, not expressing an opinion. Now, one way of looking at that issue, though, for this case, is to pick up a point made by Sir James yesterday, which is the Allah/AB point. Because the Court of Appeal, at paragraph 172, says, and I quote, "We are confident that Strasbourg has set its face against amnesties and immunity such that they say the 2023 Act is incompatible." All that's necessary in our submission for our purposes is that it is possible that the reconciliation exception exists, or, perhaps to put it a slightly different way, that it exists, but the boundaries of the reconciliation exception have not been fully fleshed out or established. And the task of a domestic court under Allah and AB is only to find a violation if it's fully confident that Strasbourg would do the same. And at the very least, we respectfully submit that the lack of an explicit Grand Chamber rejection of amnesties, especially given that the Chamber had done so, would support the fact that a domestic court can't be fully confident of what Strasbourg would do. Now, let me pick up a couple of other points made against me, so to speak, on Margus. One of the points made against me on Margus is that my learned friends look at the later decision in Meccano, and I'll give the reference, it's at 9759. And they say, if you look at the partly dissenting opinion of Judge Wojciech in Meccano, he says, and this is at 9829, he says the decision in Meccano is in quotes partial incoherence with Margus. Now, in my respectful submission, my learned friends can get absolutely nothing from Meccano, nor from Judge Wojciech's partly dissenting opinion. First, Meccano is not an amnesty case at all. Second, the idea that the Grand Chamber in Meccano were overruling or rowing back from what they said in Margus 139 is belied by the fact that they don't even cite Margus in Meccano. It's never cited. The only person who cites Margus in Meccano is Judge Wojciech in his partially dissenting opinion. And given that he was in Meccano, forgive me, given that he was in Margus, what he's plainly doing, in my respectful submission, is he's saying, just be careful, don't extrapolate from the general statements in Meccano that what we said in Margus doesn't still apply. In fact, he's making the precise opposite point. He supports, in my respectful submission, the point I'm making. In any event, all this is somewhat overtaken by events, because in the yet later case of McEvoy and Azerbaijan, which you have in our supplemental bundle at 509, the court there cites at paragraph 160, which is at 558, the same paragraph 139 in Margus, which my learned friends say Meccano had, quotes, firmly closed the door on, close quotes. So that door wasn't firmly closed. It was always open, and McEvoy confirmed that it remained open. Now, given the time, I was going to, because I need to leave time for my learned friend Mr. Dinsmore, I was going now to turn to the second point, but let me just take perhaps a moment just to draw the threads together on the reconciliation exception, because I appreciate I've taken this quite quickly, but I hope we've set it out clearly in writing as well. First, we say Margus forms part of what we say is a clear line of authorities recognising the existence of a reconciliation exception. Although I've dealt with it alone today, it is not a one-off case. Second, Margus recognises, as I've done, the general positive obligation, see paragraph 127, and then refines it and puts it in context after an analysis of the international law position. And it does that in its conclusion at 139. Third, we say Margus 139 clearly restates the exception. And we also say when you crunch through the separate individual judgments, the majority of the judges in Margus do not reject the reconciliation exception. Fourth, we say Meccano is a totally different context in which Judge Wojciech is actually warning not to extrapolate from the general positive obligation that there is no reconciliation exception. And fifth, the most recent case of McEvoy again picks up Margus 139, which contains that exception. And so sixth and finally, we say our submission is that the reconciliation exception clearly exists, or at the least, very least, exists with unclear boundaries, which is my sort of other gloss on it, such that the High Court and Court of Appeal in this case went beyond the Uller and AB principle in holding that they were fully confident that Strasbourg would find that the exception doesn't apply in this case. So let me now turn to the second point I was going to make, which is what are the limits of the reconciliation exception and can the conditional immunities fall within it? And I've already said that in our submission this would be a paradigm case for the reconciliation exception. The Act has as one of its aims, not only in section 2.4, but actually also in the title, reconciliation and the promotion of peace. And of course the Act contains within it a series of measures which taken together, and that is an important point, you can't isolate this subsection or that subsection. The way this Act works is that there are balances within it, and it's meant to work overall as a way of achieving reconciliation. The starting point is that you've got to be truthful. And that's a thrust of the Act, that you provide honest information, and that is the way to an immunity. We say none of the facts found by the learned judge stands in the way of that conclusion. The essential facts found by the learned judge are in paragraph 187 of his judgment, which is at page 516 of the electronic bundle. Just to pick those facts up, he found that there was no evidence that the granting of immunity under the 2023 Act will contribute to reconciliation in Northern Ireland. He considered the evidence was to the contrary, and that's the central factual finding which the Court of Appeal at 355, paragraph 10, says was open to the judge. Now, it's called a factual finding. It might be said it's really a prediction, but even if we accept it as a factual finding, what's interesting is that in the same paragraph 187, the learned judge goes on to opine that a different reconciliation system where victims could initiate the request for immunity in exchange for information could be compliant with Articles 2 and 3. There's no explanation from the learned judge as to why that makes the difference for Article 2 and 3 purposes. How to strike the balance, how the reconciliation system is going to work is, in my submission, a paradigm matter for Parliament and not for the court. But in any event, we say respectfully that the judge was asking the wrong question. The question here where we're discussing striking down an act because it falls outside the reconciliation exception is not whether a court considers that the policy will work, it's whether the government which introduced it to Parliament bona fide considered that it might work. In other words, was reconciliation one of the aims of the policy? Now, that point is simply answered because it's in the common ground. Paragraph 19 of the agreed statements of facts and issues for this case confirms that the aims pursued by the legislation included, and I quote, reconciliation and the promotion of peace. Now, what's slightly odd in this context is my learned friends, the respondents, paragraph 12 in their responsive document to my intervention, where in the first sentence of paragraph 12, they quote paragraph 19 of the Statement of Facts and Issues, but for some reason they only quote the first bit, the bit about vexatious claims against veterans, and they don't quote the second bit of paragraph 19. Well, both bits of paragraph 19 are as much agreed statements of facts as each other. Secondly, in the second sentence of their paragraph 12, they say, my clients seek to go behind this agreed fact and argue that the sole or principal purpose of the Act was reconciliation. Well, we don't. The word sole doesn't appear in our written case at all. The word principle does appear, but doesn't appear in relation to the Act. I simply do not know where that submission has come from because it's not our case. We stand firmly on the Statement of Facts and Issues. Now, once that central point is borne in mind, i.e. what is the actual question, the other factual findings made by the judge, and I said I wasn't challenging them and I'm not, they fall away as not being relevant or directed to the essential question. First of all, the fact that the Troubles ended in 1998, as the Act itself states, so this is a form of sort of statutory fact in any event. I mean, the fact that the violence ended in 1998, or is deemed to have ended in 1998, doesn't mean that there's no conflict thereafter, or no need for a reconciliation process thereafter. And there's certainly nothing in the authorities to say that you can't have a reconciliation exception which begins a few years after the guns have fallen silent. So that fact, in my respectful submission, goes nowhere. The next factor was that political parties in Northern Ireland didn't much like the Act. I think I said a word about that already. We also have to bear in mind, in my respectful submission, what we're dealing with in the context of this Act. There is a temptation to assume, and I think the respondents assume this, that the effect of the immunities is to let people walk free who would otherwise have been convicted of very serious crimes. Now, first of all, although my learned friends focus on armed forces veterans, of course the immunities apply across the board to all combatants. That also underlines why the entirety of the UK, and not just Northern Ireland, is engaged in this issue. People were killed and maimed on the mainland. Members of the armed forces come from the mainland. Reconciliation is required, in my respectful submission, for the whole of the United Kingdom, not just for Northern Ireland. But to come back to the point, much of my learned friends submission read on the basis that but for the immunity there would have been a conviction. Well, why, with respect, do we assume that? Not least, given the passage of time, there is a real prospect that there wouldn't be convictions. And part of the reconciliation process, part of setting in train and putting in place a reconciliation system, is to acknowledge that families who suffered anguish may suffer greater anguish if a conviction fails than they might do under an immunity granted in a reconciliation process in exchange for information. Lastly, in this context, I should also underline the points, I think this was mentioned yesterday, that the predicates for obtaining immunity are that the person has requested immunity, the panel is satisfied they're telling the truth, and that the disclosed information would expose the person to criminal investigation. But it's important to note that the immunity can be revoked not only if you lie to the panel, but also if you're convicted thereafter of further terrorist offences. And that means, in my submission, that the immunities here are rightly seen as conditional. I mean, that word has been in dispute, but in my submission they are conditional immunities. They're conditional at both ends, if I can put it that way. There are conditions to be satisfied to get the immunities, and there are conditions under which you lose the immunity as well. Before I say a very quick word about remedies, can I just underline this point, which explains, I hope, why, so to speak, I'm on my feet, and why we respectfully invite the court to deal with the submissions I'm making, whatever conclusions the court reaches on the other points. That's because we do respectfully submit that the decision of the Northern Ireland Court of Appeal does threaten the architecture of the peace process. As we set out in our written case, paragraph 8.3, another element, for example, in that architecture is the early release of prisoners. Now, they are by definition people who were guilty and had been convicted. There is Strasbourg authority, which we cite, that early release can breach Article 2. If the reconciliation exception doesn't apply, would, I ask rhetorically, that be vulnerable as well? That is a central element of the peace process. Now, one might say, well, they've been released, who's going to bring a challenge? But that's not really the point. The point is that the whole peace process was an interlocking system, a mechanism of immunities, of changes in legislation, all designed overall to bring about the reconciliation which was fundamental to the process. And we do respectfully submit that the wrong decision of the courts below on the ECHR issue should not be allowed to stand. Let me finish with a very quick word about remedies, which I've dealt with this in paragraph 22. And I'm very conscious that I'm here as an intervener, so there's probably limited things I can say about this, but I hope I'm not overstepping the mark on this. We do respectfully submit that if the court is with me on the central point that I've been submitting, i.e. that the conditional immunities are compatible with the ECHR, then respectfully, and I think I have to put it in this way, you should consider quashing the declarations of incompatibility, because those declarations would then be inconsistent with the legal conclusions which you would have just found. And if you need authority to do that, you've got it under Rule 32. Now, I appreciate, of course, that neither party to my right or my left are asking you to do that, and I'm an intervener. But I hope I can ask the court to consider doing it, so to speak, of its own motion, because it would logically follow from the legal decision you would have made. There is also, and I will end with this, there is also an important constitutional point here, which is this. Under Section 10, as the court knows, of the Human Rights Act, the Secretary of State is given something of a, can I call it, a sort of a fast-track procedure by way of a remedial order, where there's a declaration of incompatibility. It simply can't be right that on a proper construction that can be used when in fact there is no incompatibility. So if there is no incompatibility, with respect, the court should consider saying so and quashing the declarations of incompatibility. Now, the court might be thinking, well, this is all very nice, but this horse might have bolted the stable, because yesterday lunchtime the Secretary of State told the House of Commons that he was introducing a remedial order. Now, that gives rise to this point, which I mentioned to learned friend Sir James, and said I would just mention, because I can't really make submissions on it. It's not entirely clear to me that in the circumstances of this case, the preconditions for a remedial order set out in Section 10.1 of the Human Rights Act have been met. I'm not asking the court to consider that point or to rule on it, but I wouldn't want it said that I never mentioned the point. It all depends, if I may say respectfully, how you look at 10.1 in the context of 10.2 and 10.3, and then in 10.1a in the context of 10.1b and 10.1c, and then 10.2. But that is a matter for another day. With that somewhat cliffhanger ending, unless I can assist the court further, I was going to hand over to learned friend Mr. Dinsmore.
Thank you very much, Lord Wilson. Yes, Mr. Dinsmore.
My Lords, I shall address the court on the Victims Directive. Let me begin by properly contextualising where these submissions fit in the analysis. They are best viewed as a further elaboration of the appellant's submissions on no diminution. In my submission, if there is no breach of the Victims Directive, then there is no diminution of EU law rights that justify disapplication. With respect, the analysis of this question has not been precise in the lower courts. Both of the lower courts engage in lengthy analyses of the compatibility of the conditional immunities with the ECHR, and then treat their analysis of this issue as if it flowed from that conclusion. Mr. Justice Coulton does so at paragraph 608. I think it's best summarised by the Court of Appeal at paragraph 310C, which can be found at page 457, where they state, the stripping away of the criminal process necessarily offends Article 11 of the Victims Directive. With respect, neither judgment properly addresses the three areas of analysis required under Article 11. First, is there a relevant decision not to prosecute that falls within Article 11? Second, is there an inability to review that decision? And third, do any of the exceptions in Article 11 apply? With that in mind, my submissions will focus on those 3 points in Article 11 and will then turn to Article 16. Turning first then...
The second of the three questions again, please.
Pardon?
Could you just remind us of the second of the third question?
The second is there an inability to review that decision?
Thank you.
And then the third is whether any of the exceptions apply. Turning to the first area of analysis, the decision not to prosecute, the respondents' most recent position in their reply submissions at paragraph 69 to 70 indicate that the relevant decision is both the Act itself and ICRIR's decision to grant individual immunities. The High Court held that it was the Act itself, and that's a paragraph 607, which can be found at page 622. And similarly, the Court of Appeal held that it was the Act itself at paragraph 129, which can be found at page 396. I will therefore deal with both the Act as the relevant decision not to prosecute and the ICRIR decisions as the relevant decision not to prosecute. Turning first to the Act, our case on this is at our written case, paragraphs 24 to 30. In short, our case is that this could not be a relevant decision because it is a matter of national policy and that the Victims Directive is aimed at individual decisions not to prosecute by prosecuting authorities. There are four aspects to this argument. First, the wording of the Victims Directive does not suggest it was intended to apply to an Act of Parliament. That's clear in my submission from Recital 43, which can be found at page 5588, and I quote, "The right of review of a decision not to prosecute should be understood as referring to decisions taken by prosecutors and investigative judges or law enforcement authorities such as police officers." And at the end of that recital it states, "The right to a review of a decision not to prosecute does not concern special procedures such as proceedings against members of Parliament or government in relation to the exercise of their official position." So pausing there, we say if the Act is the relevant decision, that must mean that Parliament is the decision maker, and that simply does not fall within Recital 43, which is concerned with what we would traditionally understand as prosecutors, investigative judges, or law enforcement authorities. Recital 26 also supports this submission at page 5578. We can see that in the left-hand column, third paragraph down. Quote, "When providing information," this is to victims, "sufficient detail should be given to ensure that victims are treated in a respectful manner and to enable them to make informed decisions about their participation in proceedings."
Could you remind me of the recital number, please?
Number 26.
26, thank you.
Thank you, my lord. In this respect, information allowing the victim to know about the current status of proceedings is particularly important. This is equally relevant for information to enable a victim to decide whether to request a review of a decision not to prosecute. That information would not be relevant if the relevant decision maker were an Act of Parliament. The second strand of this argument concerns the wider EU materials, and in particular the DG guidance. This was relied upon by Lord Justice Rafferty in the AC decision, paragraph 36, which can be found at page 6376, and it was also cited by Mr. Justice Colton at paragraph 608, which can be found at page 623. This is the EU's key explainer on the national implementation of the directive.
Sorry, the page again, please.
The page for Mr. Justice Colton is at 623. The DG directive is quoted at paragraph 25 of our written case, which is in the supplementary interveners bundle at pages 24 to 25. And it states, I quote, "Its object, namely of the Victim Directive, is not to criminalise certain acts or behaviours in the Member States. Thus, the directive will apply and define as a victim a person who has been a victim of specific conduct, depends on whether such acts are criminalised and prosecutable under national law." Now, the respondents do not respond to this in their reply, and my respectful submission, that's unsurprising, because that is exactly what the respondents are seeking to do. They are seeking to render certain conduct prosecutable under national law, and the DG guidance is clear that that is not what the directive is intended to do. For completeness, the Court of Appeal failed to refer to this guidance at all in their judgment. The third strand of this argument concerns case law. We say there's no UK or CJEU case law in support. The key relevant case is the RAC and Director of Public Prosecutions case. Paragraph 37 of that judgment, it states there's no right to review in all cases, but rather the directive contemplates a right to review in accordance with the victim's role in the relevant justice system. And in my submission, the directive does not mandate when one should be regarded as a victim within the relevant criminal justice system, but rather is concerned with participatory rights once inside it. Further, at paragraph 46 of that judgment, Lady Justice Rafferty makes clear that Article 11 does no more than set out procedural rules. The fourth limb to this argument is that it should be read consistently with the ECHR. I'll take this very briefly, which is to say, if your lordships are with my learned friend that the Legacy Act falls within the reconciliation exception, then we say, when considering what a relevant decision is, to be consistent, any national policy about such reconciliation would fall outside of such a decision. I don't have time orally to go through the practical implications of the respondent's argument, but they are stated at our written case, paragraph 30, touching on 5 key areas that could be affected. My lords, that deals with whether or not the Act of Parliament itself can be a decision not to prosecute. Very briefly, whether each individual grant of an immunity by ICRIR could be a decision. The simple point is that ICRIR is not a prosecuting authority. They can grant immunities, which is a national policy about whether a crime is prosecutable, which is outside the directive for the reasons I've just given, or under Section 25, they can refer the case to a prosecutor. But they are not a prosecutor whose decision could fall within Article 11. Turning then to the second area of analysis, which is whether there is a lack of review. If your lordships conclude that this is a decision, not the Act is a decision not to prosecute, I would respectfully submit that these proceedings could constitute such a review. The Act could have banned all judicial oversight. It didn't. We are here now reviewing it. And indeed, it's difficult to think of what other act of review could be appropriate to an Act of Parliament. Insofar as the relevant decision is that of ICRIR, I have 2 brief submissions. First, there is a right to go to court to have the immunity revoked under Section 26, which is a form of review, and Article 11 does not mandate the form or extent that a review must take. And the second form of review is, of course, judicial review. Now, the respondents may say, well, that's not reviewing the substance of the decision. But as Lady Justice Rafferty made clear in the AC decision, the Victims Directive does no more than set the procedural rules. If that's correct, the adherence to those rules and the procedure is entirely appropriate for judicial review, and in my submission would be the apt review for such a procedural analysis. Coming to the third area of analysis, the exceptions, we respectfully submit that if either the Act or ICRIR's decisions are regarded as a decision not to prosecute, they are best viewed as an out-of-court settlement. The language of 11.5 is very broad. It doesn't define what an out-of-court settlement would be, and we submit that this would be a paradigm case. The immunity is given where it is requested, truthful information in relation to conduct forming part of the troubles is given, a specific or general immunity is granted, and the individual then does not proceed to commit any further crimes. This is a classic example of a trade between the state for truthful information in exchange for non-prosecuting. It's akin to a whistleblower in the mafia. It's akin to the decommissioning immunities, the location of remains. In all of those circumstances, you effectively have a settlement between the state and the individual in exchange for that truthful information for an immunity.
Which particular provision of Article 11 are you referring to?
11.5, my lord. which states that paragraphs 1, 3 and 4 shall not apply to a decision of the prosecutor not to prosecute if such a decision results in an out-of-court settlement, insofar as national law makes such provision. My Lord, I'm aware of the time, and so I will wrap up briefly with Article 16. We say the critical words in Article 16 are in the course of criminal proceedings. They do not mandate criminal proceedings. If the court agrees that these immunities do not breach Article 11, so the decisions not to prosecute are national policy, we say it would be inconsistent to conclude that through the back door, Article 16 now mandates criminal prosecutions again. And my final point would be, if you remove the words in the course of criminal proceedings, then you get the unconditional right the respondents are pushing for. However, the presence of those words indicates that there is no mandatory criminal proceedings. Unless your lordships have any questions, those conclude my submissions.
Thank you very much, Mr. Dinsmore.
My Lord, we're going to do things in reverse order, so I'm going to address the European Convention on Human Rights, and my learned friend Mr. Larkin is going to follow on the Windsor Framework.
Very well.
I hope to finish around lunchtime or soon thereafter. I'm going to structure my submissions in the following 4 ways. First, I'm going to address immunities. Second, victim participation. Third, disclosure. And then finally, coming back to Sir James's point, what is the test to apply when assessing incompatibility in this case? In each of those first 3 stages, I'm going to try and be forensic if I can. So what does the Act actually do, to answer Lord Stephen's point to Sir James? What does the Convention actually require? And is there a breach of the Convention as a result? Turning, if I can, to immunity, and without prejudice to the points that we've set out in writing as to whether these points are properly raised in the appeal at all, given that it's agreed by all of the parties in this appeal that the immunity provisions are incompatible with the Convention, can I ask the Court to turn up M5278, which is where we see Section 19, so 5278 of the main bundle.
Sorry, the page number again, sorry?
5278.
Thank you.
This is Section 19, which is the first of the kinds of immunity which arises under the Act. And the Court will see straight away the wording of Section 19.1. The ICRIR must grant immunity if those conditions are met. It's not may grant immunity, as we can see in some of the other kinds of cases. And these conditions are easy to meet. The first is, number 1, that you have requested ICRIR to grant you immunity. The second is that ICRIR is satisfied that your account is true to the best of your knowledge and belief. And in that regard, it doesn't have to be new information. Section 19.4 says it may consist entirely of material that you've already provided. And then the next condition over the page is that it's a prosecutorial decision. Immunity once granted lasts forever. Immunity once granted can only be taken away if you are convicted of lying, see Section 26, or if you are convicted of certain terrorism offences, see Section 27. So when deciding whether or not to grant immunity, it doesn't actually matter if ICRIR think that your grant of immunity will not bring about reconciliation. It doesn't actually matter if you are joyful about your conduct, if you think that what you did was right. There's no need for an apology, regret, or recognition of loss. And there is no role for the victim to play in any of this process. That's what Section 19 says. And it's relevant to note on the evidence that when this idea was being cooked up, it was recognised by the Northern Ireland office that they had no idea if it would actually lead anyone to tell new information. And so to give the reference in the evidence to that, it's 2883, paragraph 20 of the policy paper. That's the first kind of obligatory immunity that arises under the Act. The second kind of obligatory immunity that arises under the Act, which has been ignored by Lord Wolfson, is that which is set out in Section 38 and Section 41. So Section 38 is at page 5319. And your lordships will see that this provides that as soon as the Act comes into force, there will be no criminal investigation of any troubles-related offence, save by ICRIR. And then Section 41, which is a few pages further along, at page 5323, no criminal enforcement action may be taken against any person in respect of a troubles-related offence that is not serious or connected. The definition of serious or connected is in Section 1.5 of the Act, which is at page 5240. And a serious offence is one that causes murder, death, or serious physical or mental harm. So pursuant to Section 41, if you don't cause murder, death, or serious physical harm, but you commit a troubles-related offence, you automatically get immunity from any criminal sanction without even needing to tell the truth. And so the shots that are fired that miss, the explosive device that doesn't explode, attempted murder, conspiracy to murder, possession of firearms, possession of explosives with intent to endanger life, causing explosions if they don't cause death or serious injury. You get immunity automatically under the Act for those things. Martina Dillon, her husband Seamus, was killed by a VZ-58 weapon. Those weapons have a particular pedigree in Northern Ireland and indeed have been the subject of a gist from Mr. Justice Humphreys, which the court will see at page 3202, paragraph 37. The police knew...
What page number, sorry?
3202.
3202.
3202, para 37. The police knew that these weapons had been imported. They knew that they were at a farm. They were on their way to the farm to pick them up. And the police officer tipped the people off that the police were on their way, with the result that the weapons were allowed to run. That's what the evidence suggests. That is serious criminality which put lives at risk, but it's not serious or connected for the purpose of Section 1.5. It's a life-threatening offence which is given automatic immunity pursuant to Section 41. The third way in which immunity works is that there is a time limit built into the Act. Your lordships will know that ICRIR can only investigate cases if they are requested to do so, and there is a 5-year limit on making such requests. That's Section 9.8 and Section 10.3. So if no request is made in respect of your criminality as an offender, and 5 years have passed, then there will be no criminal investigation of you by anyone. And so the question for the court is whether these three different kinds of immunities, two of which Lord Wolfson hasn't touched, are permissible under the Convention. And the answer in our respectful submission is obvious, they're not. And realistically, whether there is a reconciliation exemption under the Convention may also not matter, because Lord Wolfson now accepts the factual findings of Mr. Justice Colton, and in particular his factual findings that these immunities weren't introduced to bring a violent conflict to an end, and his factual conclusion at paragraph 187 that there is no evidence that the granting of immunity under the Act will in any way contribute to reconciliation in Northern Ireland. Indeed, the evidence is to the contrary. We have set those factual findings out in our written reply in the Respondents' additional bundle at pages 6 to 8, and the factual basis for them. And my noble and learned friend, Lord Wolfson, may have a different political view as to what may or may not lead to reconciliation, whether families may or may not be distressed by a prosecution that fails. But these are the factual findings through which this court has to address the questions. A different factual conclusion may also, I should say, apply to the schemes that were introduced as part of the Belfast Good Friday Agreement, to pick up my Lord Stephen's question, because those were aimed at reconciliation. Those were agreed by all of the political parties, save one, and by the two governments. They were approved overwhelmingly by the two votes in Ireland and in Northern Ireland. And so those are immediately different insofar as they are aimed at reconciliation. But in any event, for the reasons we have set out in our written reply to the veterans' case, they aren't properly viewed as amnesties in the same way anyway, because they allow for prosecution, they allow for sentencing, and they allow for individual discretion. And so that's the factual findings. And can I turn now to the clear and consistent line of cases in which the European Court has set its face squarely against amnesties of any kind, where such amnesties relate to conduct in breach of Articles 2 and 3. And can I ask the Court to start by turning up a Grand Chamber decision, which Lord Wolfson again didn't address. It's in the supplementary bundle at page 754, and it's a well-known case of Honor Ildis and Turkey. And towards the bottom of that page...
Sorry, bear with us a minute, please.
I'm so sorry, my lord.
The
supplemental bundle served by the intervener, the veterans, and it's page 754.
Thank you very much. Yes, thank you.
And can my lord see just at the bottom of the page is paragraph 96, and there's a second part of paragraph 96.
Yes.
On the other hand, the national courts should not, under any circumstances, be prepared to allow life-endangering offences to go unpunished. This is essential for maintaining public confidence and ensuring adherence to the rule of law, and for preventing any appearance of tolerance of or collusion in unlawful acts. That is a Grand Chamber decision. It is a Grand Chamber decision that doesn't say they can, in some circumstances, allow life-endangering offences to go unpunished.
Was an amnesty an issue in that case?
In that case, there was a prosecution, but the relevant mayor got a fine rather than a criminal sentence.
Was the court grappling with the issue as to an amnesty?
It wasn't formally an amnesty case in that sense. But what it begins, if I can give your lordships the references, is a series of 15 cases in which the European Court repeats this mantra. So the second case is Okhali and Turkey, and the reference here is Supplemental Bundle 717, paragraph 65. The third case is Nikolova and Bulgaria, Supplemental Bundle, page 696, paragraphs 57E and 61. Third case chronologically, fourth case, Durin and Turkey. This is in the Respondents additional bundle, page 38, paragraph 61. That was an amnesty case.
Sorry, the Respondents additional bundle page?
Page 38, paragraph 61. Yetter and Turkey is the fifth case. Same bundle, page 263, paragraph 63. Then Mogislaw and Poland, Supplemental Bundle 601, paragraph 53D.
Sorry, paragraph?
53, subparagraph D. And then Beganovic and Croatia, page 385, paragraph 77.
385 in...
Supplemental bundle. Then Enukidze and Georgia, Respondents additional bundle, page 105, paragraph 242.
Sorry, Respondents bundle.
Page 105, paragraph 242. Then Jelic and Croatia, Supplemental bundle 434, paragraph 77. Then another Grand Chamber decision, De Silva and the UK, Supplemental Bundle, page 307, paragraph 239. Then Hasan Köse and Turkey, Supplemental Bundle 503, paragraph 35. Then Vazagashvili and Georgia, Supplemental Bundle 833, paragraph 84. Then Makuchian.
What paragraph number again, please?
Sorry, paragraph 84 on page 833.
Very much indeed. Thank you.
Then Makuchian and Azerbaijan. The relevant page is Supplemental Bundle 557, paragraph 156. And your lordships will note that in that same authority at page 558, paragraph 160, the fourth section expressly refers to Margus as buttressing this view. So Margus is the case that my learned friend Lord Wilson tells us establishes the reconciliation exemption. And here we have the fourth section applying a prohibition on failing to punish with full reference to Margus. Then we have Mortier and Belgium, page 645 of the Supplemental Bundle, paragraph 169. And then another amnesties case, Kachatria and Armenia, Respondents Additional Bundle, page 185. Respondents Additional Bundle, page 185, paragraph 153, and page 195, paragraph 192.
So the second one, sorry.
Paragraph 192 on page 195 of the Respondents Additional Bundle. And so that is a clear and consistent line of authority from Strasbourg, including 2 Grand Chamber cases, repeating the mantra that under no circumstances should life-endangering offences go unpunished. All of those cases are inconsistent with the veterans' case because they say under no circumstances, not in some. And trying to distinguish all of those cases because they don't arise in the context of reconciliation doesn't work for 2 reasons. First, because it's clear that Strasbourg knows what it's doing. The judges who sit on these cases know the Strasbourg jurisprudence. And it is absurd to suggest that if they had established a reconciliation exception, that they would have been content to continue to set out this general and unvarnished rule. And second, because, as I've said, these cases actually refer back to the cases, such as Margus, which my learned friend Lord Wolfson tells us establish the reconciliation exemption. And so there is a line of 15 cases. And that is why the capacity for punishment has been part of the duty to investigate since Jordan, and why it's been recognised by this court in McQuillan, see page 7782, paragraph 109.6. And it's also why this court recognised the importance of punishment in the Article 3 case of DSD, page 5801, paragraph 24. So what one gets when one looks at these 15 cases is not just that clear rule, but also the clear insistence on accountability, deterrence, enforcement, rigorous enforcement, and sentencing, punishment. We also see in some of these cases it being said that you have an alternative remedy. You haven't, because you could have brought a civil claim for damages in respect of this, you haven't exhausted domestic remedies. And the Strasbourg court says no, because your civil claim wouldn't lead to punishment, which is the very point of the duty to investigate that we're looking at. And so there we have 15 cases buttressing this point. And then we have 15 more cases, my lord. I'm not going to go through these because they're set out in our written submissions at page 15 of the Respondents' Additional Bundle, paragraphs 38 to 53. And in all of those cases, the Strasbourg court says the granting of an amnesty or pardon should not be permissible under Articles 2 and 3. The last of those cases, which is Kachatria and Armenia, at the Respondents' Additional Bundle, page 198-201, sorry, paragraph 201.
Page number?
Page number 198, paragraph 201. The way they put it in that case, the court's settled case law is that an amnesty or pardon is not compatible with the duty incumbent on the states to investigate acts of ill treatment and to combat impunity. And again, the veterans are left with no choice but to seek to distinguish this additional line of 15 cases on the grounds that they don't arise in the context of reconciliation. And again, that doesn't work because these cases expressly refer back to the cases that the veterans say establish their reconciliation exception. And so to give the references here, Okali and Turkey at supplemental 719, paragraph 76, cites Dujardin, the French case that my learned friend starts with. Association of the 21st of December 1981, supplemental bundle 351, paragraph 106, cites the Ould Da case. And so once again, the court is saying we have a settled approach, which is no amnesties and punishment. And it's establishing that settled approach in full cognizance of the very cases that my learned friend Lord Wolfson says the opposite. And so given we have 15 cases saying under no circumstances can you let life-endangering offences go on punishment, 15 cases saying amnesties are generally incompatible, what is the basis for the veterans' argument to the contrary? The first is Dujardin, as we've seen. That's a 1990 case. It's an admissibility decision. It predates the establishment of the duty to investigate in McCann by 5 years. It predates the codification of the duty to investigate in Jordan by 11 years.
Can I ask you, Mr. Button, some of the references you gave us were to pages in the Respondents bundle.
Yes, my lord. I did have a concern about this.
Yes, I have a concern about it too.
Because it occurred to me when I looked on the website that you hadn't published our written reply to the veterans' case.
It's not been added to our bundles. I've just been sent a copy by my judicial assistant.
Yeah, well, I don't have it.
Well, it was up. I have proof that it was uploaded onto the portal, my lord, but it seems not to have made its way to your lordship, and I'm sorry about that.
Yes.
We have your references, but we're not able to look at them.
Yes.
Yeah.
Well,
okay. Well,
I've given the references for now. I don't intend to take the court back, I think, to that bundle for now. But
no,
it is.
That's fine.
If your lordship has, it concerns me as well.
We'll be able to look them up, and
that is where we set out our written response as well.
I'll pursue the issue of our not having the bundle.
I can forward it to you all now.
Can I apologise for that, my lord?
Well, I'm not suggesting it's your responsibility. It may be that Lord Jones can do his magic and provide it.
Very grateful to my lord.
They have reached the court clearly, but they haven't reached our bundles.
So does that mean that your lordships haven't then seen our written reply to the veterans' case? Yeah. Well, that's unhelpful. I'm sorry, because I think we were. Yeah, my Lord Wilson was referring to it in his submissions.
Yes,
that's where we set it out.
Puzzled why I couldn't find that as well.
Yes. And I think it would help if.
Right, we'll get it sorted out.
I'm very grateful.
Thank you.
Can I turn then back to Lord Wolfson's case? So Lord Wolfson's case was the first issue is Dujardin, and I've made my submissions in respect of it already. It's a case with very limited precedent value, which has never been followed, and which is fundamentally unreasoned in its conclusion at the supplemental bundle, page 414. In any event, what it says is expressly inconsistent with those two lines of authority that I've set out to the court. The next case...
I can tell you, we now have your bundle.
I'm very grateful.
Thank you.
You couldn't take me to the Strasbourg case that says paragraph 139 of Margus is incorrect.
I'm going to come to Margus in a moment, if I can, my lord.
Is there such an authority from Strasbourg?
No, Strasbourg doesn't disavow paragraph 139 of Margus, and I'm going to explain.
So all these 15 cases, when we work through them, there will be nothing to say Margus is incorrect.
No, one of them expressly relies on paragraph 139. That's why that's why it's important to understand.
Well, it would be helpful to me, certainly, if one had a look at that case to see what they say about paragraph 139.
That's the case of Kyrgyzstan and Armenia, which is in the Respondents'
Yeah,
original bundle.
got it. Yes.
And so I think it's at page 198.
That is paragraph.
Sorry, my lord. I think I've given the wrong reference, actually.
No, it's the right case.
It's actually McEvoy that I intended to bring the court to. It's a supplemental bundle. I confused two different cases.
No, not to worry.
Your supplemental bundle.
No, my Lord Wolfson's supplemental bundle. Page 558, paragraph 160.
Yes, Lord Wolfson took us to that paragraph.
Yes. And so what it says there is it expressly refers back to Margus to set out the position that paragraph 139, that amnesties are not in principle contrary to international law. I'm going to come back to Margus because Margus says two things. It says at paragraph 139, amnesties are not inconsistent with international law. And it says at paragraphs 126 and 127 that amnesties are inconsistent with Articles 2 and 3. Those two concepts are, of course, different. And so if I could just go back then to the line of chronological authority, we had Dujardin, first of all, fundamentally unreasoned and surpassed by the subsequent cases. Then we had, in my Lord Wolfson's case, Tarbuck, which is an Article 6 case. And the extent of Tarbuck is at page 804 of Lord Wolfson's bundle, paragraph 50, where it simply states as a fact what Dujardin found without making that relevant to its reasoning. Then we have the Old Da case, which, as we have seen, has been interpreted as saying that amnesty laws are generally incompatible with the duty on states to investigate torture. That's what Old Da says in terms. Supplemental Bundle 407, paragraphs 48 to 49. And then we have Margus. And Margus is obviously the case in which Lord Wolfson hangs his hat. And that's why it's important to start with what it actually says about Articles 2 and 3. And this answers my Lord Stephen's question. Page 9626 of the main bundle. Having set out the heading, the discontinuance of proceedings under the General Amnesty Act, at paragraph 124, the Grand Chamber sets out the position under the Convention, because that's what we need to look at, because this is a Convention case, not an international law case before your Lordships. And so first of all, they set out the importance of Articles 2 and 3 as fundamental provisions. Then they say what the purpose of an investigation is at paragraph 125. And at the end of that is to ensure accountability of the perpetrators. Then we have at paragraph 126, the court has already held that where a state agent has been charged with crimes involving torture or ill treatment, it is of the utmost importance that criminal proceedings and sentencing are not time-barred and that the granting of an amnesty or pardon should not be permissible. And so here we have the Grand Chamber recognising that where state agents are charged with torture or even ill treatment, not just the high threshold my Lord Jones was putting to Lord Wolfson, Article 3 breach, rather than international law grave breach. In those circumstances, the granting of an amnesty or pardon should not be permissible. Then we have, over the page...
I just found some difficulty reconciling paragraph 126 with 139.
Can I come to that? Can I come to that, my Lord? Because I'm going to explain...
139...
I'm going to explain it.
Killing of civilians, presumably by state agents.
I'm going to come to it in a moment. So paragraph 127 again, very clear. This is the position under the Convention. The court's case law affirms that granting amnesty in respect of killing and ill treatment of civilians would run contrary to the state's obligations under Articles 2 and 3 of the Convention, since it would hamper the investigation of such acts and necessarily lead to impunity for those responsible. That would diminish the purpose of the protection of Articles 2 and 3. It would render illusory those guarantees. And so that is the Convention requirements as set out by the Grand Chamber, entirely consistently with the 2 lines of 15 authorities which I've sought to bring to the Court's attention. The Court then turns, as Lord Wolfson rightly says, to the position under international law. And that's paragraph 129 and onwards, follows on from submissions from interveners in Margus's case about what international law required. And often the requirements of the Convention will correlate entirely with the requirements of international law. But here we have a context in which they are setting out the individual requirements of the Convention before looking at international law. And then we have the conclusions to this passage at paragraph 139, and this is my Lord Stephen's concern. In the present case, the applicant was granted amnesty for acts which amounted to grave breach of fundamental human rights. Then it says, a growing tendency in international law is to see such amnesties as unacceptable because they are incompatible with the unanimously recognised obligation of states. So pausing there, that sentence, my Lord Stephens, is about what international law had established as separate to and distinguished from what Articles 2 and 3 require, which is what we see set out at paragraphs 126 and 127. And then we have the speculative end of paragraph 139. Even if it were to be accepted that amnesties are possible, and this is again under international law, where there are some particular circumstances, such as a reconciliation process, the amnesty granted would still not be acceptable, since there is nothing to indicate that there were any such circumstances. And so that is the Court positing a possibility under international law and saying that that possibility doesn't apply in this case in any event. But it doesn't matter, because we have the findings at 126 and 127 that Articles 2 and 3 prohibit such amnesties. That's what Margus plainly means. Those paragraphs are entirely consistent. And they are also entirely consistent, I should say.
Why didn't they say then, at the end of paragraph 139, not that these circumstances didn't exist, but this was a killing by a state agent?
Because they were addressing what international law may or may not have established. And they weren't even sure that that had been established under international law. But look at what paragraph 140 then says, my Lord. Paragraph 140 then says, by bringing a fresh indictment against the applicant and convicting him of war crimes, the Croatian authorities acted in compliance with the requirements of Articles 2 and 3. And so that is why Margus has to be understood as an Article 2 and 3 case. And then it has its speculative consideration of international law.
It may be that you can't help us with language that isn't specific. But when we look at even at paragraph 126, the sentence that you focused on is specifically concerned with the first sentence, with a situation where a state agent has been charged.
Yes.
Now, it then goes on to refer, just to the top of the next page, to the decision in Dar, where it says the court held that an amnesty was generally incompatible with the duty incumbent on states. So it seems to be leaving some room for flexibility.
Well, respectfully, the answer is no, because it's very difficult to explain pithily why that is, but to attempt to explain, first of all, in respect of the state agent issue, that when the court looks at the 15 cases that I've set out, the court has also applied that to private actors who commit crimes or who are accused of crimes. Secondly, it's correct here that Old Da was in the context of the development of this case law. But ULDA has then been followed to make what ULDA says in respect of general incompatibility with international provisions as being general incompatibility with the Convention without exceptions. And then, just to very quickly address the various passages that my Lord Wolfson sought to bring to the court's attention in the concurring judgments. Just the past paragraph references, page 9640, 0 Roman numerals 3.
Page
9640. It's OIII paragraph 9. We share fully the majority's concern that violations of human rights must not go unpunished. Same at 9635 OI paragraph 2. 9635 OI2. Amnesty laws may be legitimate as long as they're not designed to shield the individual from accountability for gross human rights violations.
Where have you gone to? 9640, you've read the first sentence of the paragraph. One has to read the whole paragraph, frankly, to see what's being said. But anyway,
yes,
what's
giving the reference.
What's your next reference?
9635.
9635.
paragraph.
It's paragraph 2 right at the bottom in the joint concurring opinion. I'm sorry, it's the paragraph at the top, sorry. It's paragraph 5 at the top of the page. Under international law, amnesty may still be considered legitimate as long as not designed to shield the individual from accountability for gross human rights breaches.
Sorry, where are you reading from? The
Top of page 9635, third line down, that paragraph. And so essentially the point that I'm making is that when the court goes through Lord Wolfson's references to the concurring and dissenting judgments, it's clear that they all agree with the majority in respect of amnesties being generally incompatible with Article 2 and 3. And even if I were wrong about that, we see that from McAnu's case, which is the next Grand Chamber decision. And the reference here is page 9809.
Sorry, 9.
9809, paragraph 326. The court has also held, in cases concerning torture or ill treatment inflicted by state agents, criminal proceedings ought not to be discontinued and that amnesties should not be tolerated in such cases.
Sorry, you're reading from paragraph
326.
326, thank you.
So that's the conclusion of the court. And then we have Judge Wojtek at page 9834. And he cites para 139 of Margus.
Page
9834. He cites para 139 of Margus, and he says, hang on, how does your conclusion at 326 fit with paragraph 139 of Margus? And he complains that the conclusion of the Grand Chamber is too rigid. And my Lord Reid, in argument in other cases, has observed that it's important to look at dissenting judgments because it gives us an insight into what's being discussed behind the scenes. And so here, look, Judge Wojtek is saying behind the scenes, hang on, you're going too far. There is a reconciliation exception, I think. And he was outvoted in that case by the majority, and the Grand Chamber has given its rigid conclusion that Judge Wojtek is now complaining against. And so to try and perceive Judge Wojtek's dissenting judgment as being a pointer of where Strasbourg is likely to go is to look at this through the wrong end of the telescope.
And what does he mean by the court's precise position on the issue of limitation and amnesty is thus yet to be clarified?
Yes, that's what he's saying, but the majority have made its position very clear. And in any event, the end of his sentence, legitimate considerations may justify limitation or amnesty, at least for acts of lesser seriousness. Couldn't possibly apply to the Legacy Act for the reasons that I've given. And so the answer in my respectful submissions on amnesties is obvious. There's a general prohibition on them under Articles 2 and 3. That's clear from the language used by the European Court. Must not, should not, generally incompatible. And that's why both courts were correct, after full argument on this point, to find the immunity provisions incompatible with the Convention. It's why the appellant was correct to abandon the point. And it's why the veterans, in my respectful submission, accept that the immunity from disciplinary sanctions from police officers in Section 45 of the Act is incompatible with Article 2 and 3. They seem to object to the findings on amnesty only where it relates to veterans, and that may give an indication as to the political approach that they've adopted in this case. That's immunities, my Lord. Can I turn to victim participation? And again, Lord Stevens asked Sir James yesterday, what does the Act actually allow in respect of victim participation? Sir James, I think, said he would come back to it. The starting point is Section 44 of the Act. Section 44 stops all troubles-related inquests. And that's why, again, there's a problem with Sir James's analysis about all or almost all cases, because this is what the Court of Appeal was ultimately considering. Section 44 and its compatibility with the Convention. And Section 44 relates to inquest cases. It doesn't relate to the other kinds of cases that ICRIR may or may not investigate. But then, what does it also do, the Act? The Act replaces inquests with the request and investigation by ICRIR. And so the starting point is, what does the victim do in that process?
So what page number for Section 44?
I don't have that to hand.
That's right.
It's 5329, my Lord.
Sorry, could you say that again, please?
5329.
Okay.
The next passage is 5261. This is the rule, the first rule that a victim can have in an ICRIR investigation. A person making a request may include in the request particular questions about the death or other harmful conduct to which the review will relate. And it's immediately clear over the page from subparagraph 8 that the Commissioner doesn't even have to accept the request, still less investigate each of the questions. The Commissioner has a wide discretion at subparagraph 8 to reject a request. The next stage in terms of victim involvement is Section 13, which is at 5265. And it says at Section 13.1 that the Commissioner must comply with the Human Rights Act. It says at paragraph 9 over the page, subparagraph 9, that the Commissioner must have regard to any particular questions that were included in a request for a review. And that's it.
Well, under the 13.1, the Commissioner is obliged to apply Article 2 procedural obligations.
Yes.
And he's obliged to ensure that the next of kin are involved to the extent necessary to have an effective investigation.
Yes. There's a certain amount of having your cake and eating it from Sir James on this point.
It is.
It says, look at Section 13.1. It says you've got to comply with the Human Rights Act. Yeah. But in any event, the Human Rights Act doesn't require victim participation in the way that you say it does. And that's how he answers our submission. And so he can't, in my respectful submission, have it both ways. And that's why there is an innate problem with Section 13.1 in any event. It adds nothing to Section 6 of the Human Rights Act.
I don't understand that. I mean,
He's
could you explain that point?
Well, his case is that all flows from Section 13.1, and so Section 13.1 will ensure that there is adequate victim participation.
Yes.
He also says that adequate victim participation doesn't require, as we say it does, full disclosure, the ability to ask questions.
But that's a question of interpreting what the Convention requires. It's not a question of interpreting the Act itself.
Yes, I respectfully agree, but
yes.
that's the concern.
But
what section? Sorry, my Lord.
No, we were referred to Section 11, and you were saying the request could be refused, but
yes.
Presumably, in considering the request, the Commissioner would have to take account of the obligations, procedural obligations under Articles 2 and 3.
Yes. My point is this, my Lord, which is that Section 13 does not expressly require disclosure, doesn't expressly require the provision of legal aid, it doesn't expressly require victim participation.
No, but the question then is, does the convention itself require those?
Yes, and that's why at this stage, as I tried to explain in my introduction, what does the Act require? What does the convention require? Are the two separate questions. But
the Act requires compliance with the convention.
Yes, but the contradistinction here is with, for example, inquests or fatal accident inquiries in Scotland, or, for example, the new provisions which were introduced in the draft legislation yesterday. All of those things expressly require disclosure, victim participation, public hearings, and legal aid. And that's why there is an absence in Section 13. It's to be read in insofar as it applies at all, rather than being an express requirement of victim participation in this context.
But it only needs to be read in if you establish the proposition that the convention requires those things.
Yes, my Lord. I'm going to turn to that in a moment.
Yeah, well.
So at this stage, I'm simply setting out what the Act allows and doesn't allow in terms of victim participation.
Yes, but it seems to be quite significant that Section 13(1) requires the Commissioner to comply with the Human Rights Act.
Well, if that were an answer, for example, then there wouldn't need to be any of the disclosure rules that we see in inquests or fatal accident inquiries or anything else, because all of those would be public bodies which would act compatibly with Article 2 and 3 anyway. But then in terms of express involvement of the victims, the next stage is at Section 15, which is at page 5270. And Section 15 expressly requires a final report to be provided in advance to a victim. And that's added to it, Section 16 as well. And so the express requirements in the Act in terms of victim participation are the ability to ask questions at the start and the ability to be consulted at the end. The rest is a matter of implication. And so, in particular, under this scheme, as the Department of Justice reminds us, and as the Court of Appeal found, there is no legal aid for victim participation. And the reference to the Department of Justice case is at page 186 in paragraph 24. So can I now try and answer my Lord Hodge's concern? What does the Convention require in this context? I'm going to take the court straight away to the key case in Strasbourg, which is Jordan's case. And this is in the bundle, and if I could turn straight away to page 9391, paragraph 67. The problems in Jordan's case were structural. The first problem was that legal aid wasn't available until recently. And so this is the bottom of page 9391, paragraph 67. The second structural problem over the page was that under the law in Northern Ireland, you couldn't call someone who was suspected of being responsible for the death. And the third structural problem at paragraph 72 was that there was no requirement prior to 1999 for the families at inquest to receive any written statements or documents submitted to the coroner. And so at best, coroners would provide you with the statements after or as the person came to give evidence. So there was no advanced disclosure. And the government...
If I may say so, it's slightly tendentious at this stage to call these problems, because all the court is doing in this part of its judgment is describing the relevant domestic law and practice.
Yes.
Obviously, it comes on later.
Yes.
To identify what it thinks.
Yes, and when I say problems, these are the problems that the court identifies. The government arguments in that case are at 9404. Paragraph 100. And I say this simply as a point of interest, The government's arguments were that Article 2 was satisfied by a police investigation, which was supervised by the independent bodies in the DPP, an inquest, and civil proceedings. Those, according to the government, and Sir James, I think, was the only member of the council team for the government who I think hasn't yet taken high judicial office. This point is fundamentally incompatible with the government's approach to the Legacy Act, because here in Strasbourg, the government are saying you have inquests, police investigations, and civil proceedings, and the Legacy Act, of course, stopped those things. We are being presented as being the revolutionary argument, whereas in fact it's the government which is seeking to upend the status quo. What Strasbourg then does at paragraph 105 is it sets out the various ingredients of the investigative duty, which of course we now see established again in McQuillan and in all of the other cases. And the purpose of that in paragraph 105, again just to pick up on the immunity point, is to ensure accountability. And so the first ingredient, para 106, is effectiveness. And effectiveness is explained in paragraph 107, capable of leading to the identification and punishment of those responsible. Again, with relevance to the immunities case. And then, of course, you have independence. You also have promptness and reasonable expedition. And then at para 109, public scrutiny and next of kin participation. Public scrutiny is something which may well vary from case to case, whereas next of kin must be involved to the extent necessary. And those are the ingredients, because my learned friend Sir James at some stages in his argument elided those ingredients. He said it's all effectiveness. But effectiveness is one ingredient, so too is independence, so too is victim participation. Then we have at paragraph 111, an important point again for the ab ante issues. The inquest hadn't even happened yet. Paragraph 111 shows us that the civil proceedings and the inquest in Jordan's case were still pending. But nevertheless, the court found breaches of Article 2. It found breaches of Article 2 because of a lack of independence. That's at page 9410. And again, it was hierarchical independence that was the issue.
Sorry, what paragraph and page number again, please?
It's 9410, paragraph 120. Then we have the concerns in respect of the inquest. And if the court could pick it up at paragraph 131 on page 9413, the inquest was at least public. But as we can see from the end of 131, the applicant complained that his ability to participate in the proceedings as the next of kin was significantly prejudiced, as legal aid wasn't available and documents were not disclosed in advance. And then at 132, we see that hadn't been a problem in McCann. But nevertheless, there had been a delay caused by the lack of legal aid. And then at paragraph 133, a change in practice in respect of documents. And at the end of 133, on page 9414, the non-access by the next of kin to the documents didn't contribute to any significant handicap. However, the court has laid more emphasis on the importance of involving the next of kin in the procedure and providing them with information. That's why there was the finding at the end of 134 that prior to the recent developments in disclosure of documents, the court wasn't persuaded that the applicant's interests were fairly or adequately protected. So the practice had changed following the Stephen Lawrence investigation, and now there was disclosure. Prior to that change, there was a problem in respect of disclosure. And then we have the conclusion in respect of legal aid at paragraph 142. The court finds that the proceedings for investigating the use of force by the police officer have been shown to disclose the following shortcomings. the lack of independence, and then importantly, the absence of legal aid for the representation of the victim's family and non-disclosure of witness statements prior to their appearance at the inquest prejudiced the ability of the applicant to participate in the inquest and contributed to long adjournments in the proceedings. So these structural problems, which I probably shouldn't have called problems when I initially introduced them, my lord, they showed that there was a breach of Article 2 even before the inquest had been heard. And this concrete scenario faces Martina Dillon, and she explains in her grounding affidavits why she wants and needs an inquest. She can't get legal aid. She can't get advance disclosure. The next case, which again my learned friend Sir James took rather quickly, is Amin's case. Amin, the factual part of Amin begins at 6552. Amin, as we know, was a young offender who on his very last night in the Young Offenders Institute was killed by a racist cellmate. This judgment from Lord Bingham was delivered on the same day that the House of Lords delivered its judgment in Middleton's case, and was intended by the House of Lords to be part of a package in respect of Article 2. There had been a number of investigations into the killing of the deceased. First of all, at paragraph 9, there had been a murder trial, which had led to a guilty plea, an argument in respect of diminished responsibility. Second of all, there was an inquest which had started and then stopped. Third, paragraph 11, there was a police investigation into gross negligence manslaughter. And then importantly for our purposes, at paragraph 12, there had been a long and thorough investigation by an expert former prison governor, Mr. Butts, to investigate the circumstances surrounding the murder and the issue of shared accommodation generally. But as the court will note, the family of the deceased were consulted about the terms of reference. They were allowed to ask questions, but they weren't then present at any stage of the investigation. Then fourthly, there was an investigation, another long and thorough investigation by the Commission for Racial Equality, in which the family again were involved in the preparation of the terms of reference and expressed views on the procedures, but were then only allowed to participate in one day of them. And so those were the 4 investigations that there had been, and the court may consider some similarity between the long and thorough investigations by Mr. Butt and the CRE and the proposed thorough investigation by ICRIR. And my lords will see the declaration made by the trial judge, Mr. Justice Hooper, as he then was, at the top of the next page. Having assessed those 4 investigations, he held that what was needed was an independent public investigation with the family legally represented, provided with the relevant material, and able to cross-examine the relevant witnesses. The principal witnesses must be held to satisfy the obligations imposed by Article 2 of the European Convention. His conclusion on the facts, Mr. Justice Hooper's conclusion on the facts, is at page 6560.
Paragraph?
Paragraph 26, but in particular between G and H on the right-hand column. On the facts of this case, the obligation to hold an effective and thorough investigation can only be met by holding a public and independent investigation with the family legally represented, provided with the relevant material, and able to cross-examine the principal witnesses. All 5 members of their Lordship's House upheld that declaration. And Lord Bingham did in ringing terms. First of all, he cited the importance of punishment in Article 2, page 6555, paragraph 19. Then he looked at another case called Edwards at paragraph 21, where an experienced member of Her Majesty's Council, as he then was, had carried out a long and thorough investigation into a prison death, but there wasn't adequate victim participation, so there was a breach of Article 2.
655 at paragraph
19.
19, thank you.
There's the reference there to the importance of punishment in Osman's case, in his summary of the various, yeah. So Amin was actually a case about victim participation. And what Lord Bingham did is he then looked through the various investigations and he explained why they had been deficient. And at paragraph 32 on page 6564, he said that Strasbourg has laid down minimum standards which must be met, whatever form the investigation takes.
Sorry, paragraph
32, just next to G on the right-hand column, my lord. He said that counsel for Mr. Amin was right to insist on Jordan and Edwards that the European Court had laid down minimum standards which must be met. He then said Mr. Justice Hooper loyally applied those standards. He explained at 33 that it was unfortunate there wasn't an inquest because an inquest could have discharged the state's investigative obligation. And then he explained why the various investigations had not been compliant with Article 2. In particular, paragraph 36, the family were not able to play any effective part in Mr. Butt's investigation. Same in respect of the CRE. And then we see at the end of 37, whether assessed singly or together, the investigations are much less satisfactory than the long and thorough investigation in Edwards. The judge was right to reach the conclusion and make the order he did at paragraph 38. Just to go through the other members of the court, Lord Slynn at paragraphs 43 to 4 agreed that Strasbourg had set down minimum standards, and he agreed at paragraphs 46 to 9 with Lord Bingham's conclusions. Lord Steen agreed that Strasbourg had laid down minimum standards. This is paragraph 50. And he also agreed with Lord Bingham on the result at paragraph 53. Lord Hope also agreed with Lord Bingham at paragraph 54. And he explained with some probably justified pride how the system in Scotland of fatal accident inquiries would have complied with Article 2. In those, of course, the next of kin are entitled to participation. In those, of course, as we now know, there's mandatory legal aid for victims. Lord Hutton agreed with Lord Bingham at paragraph 66. And so what we have here in terms of the requirements of the Convention are Jordan's case and Amin's case laying down minimum standards. And those minimum standards include legal aid and disclosure to the victims. And Sir James's answer to those two cases is to counter with Finucane's case. But again, with respect, that doesn't assist him. Because as he says, it's all about what Finucane doesn't say rather than what it does say. What Finucane does say is that it was a case about effectiveness, the first ingredient in the Strasbourg standards. And your lordships will see that page 7690, paragraph 138. That was the only ingredient that Lord Kerr actually looked at in terms of finding a breach of Article 2. He didn't actually go on then to also find what the law was in respect of victim participation. And so to say that Finucane didn't show that you needed to have cross-examination and legal aid doesn't assist Sir James in the way that he does, especially when you have two cases, Jordan and Amin, which show that you do. No one suggests that Amin was wrongly decided or should be departed from. And it's important also, again, that both of those cases have been followed in England and Wales to establish a right to legal aid where Article 2 requires it. And to give the references here, the first is Humberstone in the Court of Appeal. And the references here are page 6860.
Sorry,
6860 at paragraphs 73 and then at 77. Humberstone's conclusion in that regard was approved by this court recently in McGuire, and the reference here is 6981, paragraph 31. And Jordan and Amin were approved in terms of showing a right to legal aid by Mr. Justice Green, as he then was, in Letts. And the reference here is at the top of page 6809, and then again at paragraphs 68 and 70.
Sorry, could you give those references again, please?
So the very top of 6809,
Yes.
and then again at the bottom of paragraph 68, and again at paragraph 70. So
6809, did you say?
6809.
At the very top.
No, it's 6909, my lord.
6909.
So sorry, that's my mistake. And so Jordan and Amin at the highest level, the Court of Appeal in Humberstone, Mr. Justice Green, as he then was, in Letts. And then, of course, the third ingredient in terms of what Strasbourg requires is having regard to the facts. And the facts here were found by the Court of Appeal. All three members of the Court of Appeal in our case had sat on legacy inquests, including one, Mr. Justice Schofield, who was sitting on a legacy inquest, I think, at or around the same time that he heard argument over the 5 days in this appeal. So they were very well placed to understand what Article 2 investigations looked like in Northern Ireland. And they expressed their conclusions at page 430, paragraph 218. As this court knows collectively from its own experience of hearing inquests, these are complicated historical cases which require oral evidence, the examination of witnesses, and in-depth focus on disclosure to be effective. Furthermore, these cases also require the expertise and participation of lawyers in what has been described as a quasi-inquisitorial setting with adversarial aspects. And so the Court of Appeal knew what an Article 2 investigation looks like in Northern Ireland and had a particular advantage over this court in that sense. And they were making those conclusions about what Article 2 and 3 require in that context.
Could you tell me again, please, the paragraph number?
It's para 218.
218, thank you.
They also added, of course, that where they begin in their judgment at page 354, paragraph 4, having set out the facts of the four applicants' cases, the Court of Appeal says, these people carry with them the visceral pain of brutal events from our past. And so when considering victim participation, the Court of Appeal knew that many of these victims suffer with visceral pain from the brutal past in Northern Ireland. And that is another pointer as to why they considered that Article 2 and 3 required effective representation and the provision of legal aid to ICRIR. And so what we now can see, standing back from that detail, is a minimum safeguard established in Strasbourg, described as such in Amin, applied repeatedly domestically, and then applied in this factual context by the Court of Appeal with its experience of what is required. And that is the application of an objective minimum standard under Article 2 to a specific context, which is unobjectionable. And it is my respectful submission that this minimum standard of effective victim participation will therefore be breached in all or almost all inquest cases, which is what we're talking about when we're looking at the incompatibility of Section 44.
I wonder whether you're able to help as to whether across the Council of Europe, the member states of the Council of Europe, legal aid is.
I haven't done that analysis, my lord. I
wonder if I could put the question another way, and that is, are you aware of any country in which it is not?
Again, I haven't done an analysis. I don't think either of the parties have. I can say, however, that mindful of my Lord Hodge and Lord Reid sitting on the panel, I did try and investigate what the situation was in Scotland. And in Scotland, its legal aid is provided on a non-means tested basis. And that, of course, follows on from, I think, recommendations made by Dame Angelini in her report in respect of deaths in custody. And so, in that sense, the Court of Appeal's judgment is entirely unobjectionable from a victim participation perspective. And that brings me to the third stage in my argument, which is about disclosure. And our submission is, what does the Act require? And our submission is that the Act gives the Secretary of State the power to decide issues of disclosure rather than the judicial body, ICRIR. And to make that point good, can I take the court through the Act again? So the starting point, as Sir James reminded us, is page 5305, section 30.
I think in some of its more recent case law to do with inquiries into troubles-related deaths in Northern Ireland, the Strasbourg Court has expressed some disenchantment with the way in which these inquests have become adversarial contests, with every possible point being judicially reviewed and so forth. Well, and I think they've indicated that the normal requirements, or requirements that have been, the requirements in relation to victim participation, public scrutiny, disclosure, and so forth, may be modified in that context.
I don't know the case that my Lord is referring to.
Well, an example that's in my mind is a case called Gribben.
I'll have a look at that.
I don't think it's in the bundles.
I'll have a look at that over lunch, my Lord. What I will, however, conclude on is, again, to answer, I think, the point that my Lord Reid asked Sir James yesterday, what does the Council of Europe say about the Act? Because we know that... About this Act.
Oh, yes.
Yeah, and I'll answer that at the end of my submissions. Sir James said...
What's the impact of the Council of Europe saying anything? It's slightly different from following a consistent line of authority of the court.
It's section 2.1d of the Human Rights Act, which requires this court to have regard to any conclusions expressed by the Committee of Ministers of the Council of Europe when looking at, and we know that there are a line of these cases. And just to explain, they say that the Act needs more on disclosure. They say that the Act needs more on victim participation. They strongly urge the repeal of the immunity provisions. They can't express themselves more strongly than they have done. And so just to go back then to disclosure, because this is the third stage of my argument. Sir James said that section 30, subparagraph 1, allows ICRIR to disclose any information to any other person. But what he didn't then show is what then happens under section 32 and onwards, because disclosure is actually prohibited in respect of the various categories, which include sensitive information at subsection 4. Section 30 is not the only prohibition on disclosure. Section 4, which is at 5248, is another chill on disclosure, because it says at section 4.1, ICRIR must not do anything which would risk prejudicing the national security interests of the United Kingdom, or would risk putting any life or safety at risk, or would risk having an impact on any potential criminal proceedings.
Sorry, what provision is it?
Section 4.1 at page 5248.
Thank you.
5248.
It's not just that the Act prohibits disclosure in those contexts, it's that it's actually a criminal offence for anyone within ICRIR, including the judicial bodies, to prohibit to disclose information. And we can see that criminal offence at page 5474, Schedule 7, subparagraph 1. So if I, as a judicial commissioner sitting in ICRIR, decide that it is necessary to disclose information to the next of kin, but it's prohibited under those provisions, I commit a criminal offence if I provide the victim with the disclosure they need to ensure effective participation. And we explain this further in our written case at page 86, paragraph 23, because this is all about what Schedule 6 allows.
Sorry, your written case, page.
Page 86, paragraph 23.
Thank you.
So if ICRIR determined that they wanted to provide sensitive information to the next of kin to enable them to play an effective role, they would have to first of all ask the Secretary of State for permission to do so. We see that from Schedule 6, paragraph 4 on page 5459. 5459. And the Secretary of State, as we can see, may notify at paragraph 4, subparagraph 3, that the proposed disclosure is prohibited only if, in the Secretary of State's view, the disclosure would risk prejudicing or would prejudice the national security interests of the United Kingdom. So the sole question for the Secretary of State, when considering whether to allow that kind of disclosure, is whether it would risk prejudicing national security interests. There is no requirement for the Secretary of State to balance the fairness or effectiveness issues that we've looked at.
I thought Sir James had conceded yesterday that the Secretary of State, being a public authority, would be subject to the Human Rights Act and therefore would have to take into account the obligation for an effective investigation.
I recollect, my Lord,
Yeah.
putting that question to Sir James twice,
Yeah.
and I think, with respect to Sir James's answer, wasn't quite as fulsome as...
Well, I think it's going to be... Well,
and the issue here, of course, is that that is the sole question. And then, if, subparagraph 4, if the Secretary of State prohibits it, they don't even need to provide full reasons to ICRIR as to why they've taken that decision. And so I, as a victim, may never know that this process has happened. I will have no ability to challenge that disclosure decision by way of judicial review or anything else, because it's a decision taken by the Secretary of State, who doesn't even have to tell ICRIR why he has taken that decision if that would risk prejudicing national security interests. And then, how can that even be judicially reviewed? I've said it can't. The only form of judicial control of decisions in respect of disclosure are at Schedule 6, paragraph 7 at 5454. Not sure that is it. 5464, I'm sorry. 5464. And the court will see straight away that the challenge only applies where it's proposed to disclose sensitive information in a final report. So the only express challenge built into the Act is in respect of disclosure in a final report. Whereas, of course, what we are looking at this stage is the advanced disclosure that Jordan requires, the advanced disclosure that Amin requires. And so, in respect of this issue, my learned friend Sir James said, well, all this could be challenged by way of JR. But we may never know. Then he said that U3 was of relevance. But of course, as my Lord Reid pointed out, U3 was a decision about a court or a tribunal, the SIAC as it's called, taking a decision about what was required in national security questions and whether or not it could go behind a national security assessment of the Secretary of State. Here, the decision maker isn't ICRIR, it's the Secretary of State. And so it's the Secretary of State inserting himself directly into the question of disclosure in what is supposed to be an independent and an effective investigation. And so none of this is the kind of PII balance that this court has looked at recently in Thompson. None of this is the kind of fair procedure that would follow on from a Section 19 Inquiries Act restriction order being made, where there would be a restricted hearing. The family could be represented either by counsel to the inquiry or by special advocates. This is disclosure being prohibited by a member of the executive, and then no ability for the victim to see it. And we say, in terms, that the appellant's control over disclosure is a victim participation issue, because the appellant can stop the victim from ever obtaining the information that they need to play an effective role in their Article 2 investigation. Bear in mind, I would respectfully urge, the European Court's explanation in Jordan of the premium that it has placed in recent years on advanced disclosure. We know why advanced disclosure is needed. I'm old enough to remember presenting inquests and not having witness statements in advance, being handed the witness statement as the witness gave evidence, and having to prepare cross-examination on the hoof. It's a significantly less effective way of playing a role in an inquest than having advanced disclosure of the documents that you need in order to see previous inconsistent statements and everything else. And so when we look at disclosure and the Secretary of State's control over disclosure, we start from the proposition that it's a victim participation issue. It's also an independence issue. And we've seen from Jordan's case how an institutional or hierarchical link between the persons being investigated and the investigator can be problematic. And Sir James said, well, this is all about practical independence. Again, with respect, it's not. It's about hierarchical independence. The same feeling arose in Brecknell's case, and the reference here is page 8710, paragraph 76. The possibility of hierarchical independence breaching Article 2 was emphasised in McQuillan at page 7810, at paragraphs 195 and 196 onwards, contrasting practical independence with hierarchical independence. And then after Tunk in particular, we have the case of Baranin and Montenegro, which is another example of post-Tunk hierarchical independence being breached, irrespective of whether there were also breaches in the effectiveness of the investigation. And so the reference for Baranin and Montenegro is 8640 at paragraph 144. And so in our respectful submission, it is inherently hierarchically problematic for the Secretary of State to insert himself directly in to disclosure decisions in what's supposed to be an independent investigation. And in this regard, can I emphasise some of the relevant facts? The Secretary of State is a defendant in many legacy civil claims. Your Lordships have the case, the statement of claim in McManus at page 2117, in which the Secretary of State is a defendant. The Secretary of State is also a potential properly interested person in legacy inquests and has played a direct role in respect of disclosure in legacy inquests, as your Lordships know in Thompson. The Secretary of State was, throughout the Troubles, institutionally responsible for national security, the running of agents and informants. And we see that in footnote 16 to our written case at page 96. And so how can it be said, just to finish off, of course, we also know that the Secretary of State's office expressed itself in the extreme and tendentious terms that it did about legacy cases, calling them a witch hunt, calling them vexatious claims. And in those circumstances, how can it be that the Secretary of State is hierarchically independent when he has expressed himself in that way and played such a role in delaying disclosure, in opposing disclosure in legacy cases? And here again, it's the legislation itself which is at fault, because it removes inquests and it replaces them with an investigative body that cannot have publicly funded next of kin, cannot ensure full disclosure, and cannot ensure criminal accountability because of the immunity scheme. My Lords, that's the first three stages of my argument. The final stage of my argument is to look at what the correct test is when assessing incompatibility in this case. As the court will have seen, the Court of Appeal actually applied Sir James's test. It found that there would be incompatibility in all or almost all inquest cases. And for the reasons that I've given, it was right to do that. These are problems which are intrinsic in the legislation, which fails to meet those minimum safeguards that Strasbourg and this court and the House of Lords have set out. But we go further, and our proposition is that the Court of Appeal didn't need to apply the all or almost all test. And this issue requires us to assess what the actual rationale for that test is. And Sir James brought us to paragraph 14 of Abortion Services and said that was the rationale. But with respect, that paragraph sets out what the test is. It doesn't necessarily express why that test applies. We suggest there are two particular reasons why this court has adopted this test. The second reason is a reason given by this court very recently, which Sir James didn't bring your lordships to. But the first reason for this deferential test is that it's been developed specifically in qualified rights cases. BB, Christian Institute, Article 8 proportionality assessments. McLaughlin, an Article 14 differential treatment justification case. Abortion Services, Articles 10 and 11. My Lord Reid started his analysis at 5917 in Abortion Services by asking the specific question, what is the test of whether a provision is beyond legislative competence on the ground that it will result in a disproportionate interference with a convention right? Why should that test then apply to an absolute right or to a minimum safeguard, as we have seen? Proportionality is, as my Lord the President reminded us in Abortion Services, a question of law calling for assessment in the light of the facts of the case. That's why in qualified rights cases we look at what is necessary in a democratic society. And that's a question which can lead to different results in different categories of case. That's the first reason why this court has adopted such a deferential approach to assessing proportionality in advance. And of course, that rationale doesn't apply here, where what one is looking at is minimum standards and clearly stated rules or absolute obligations under Articles 2 and 3. An absolute right or a minimum standard is one that doesn't allow for different results in different categories of case. Where the Convention has set those minimum standards, it is a breach of the Convention to fail to do so. But the second, and the one which is more clearly established in this court's jurisprudence rationale, is that which is set out in JR 123. And that is that the rationale for this deferential test is because it applies where this court is assessing whether to strike down devolved legislation. Christian Institute and Abortion Services were cases which came before this court as references to test whether the devolved body had the power to make the legislation an issue. The very passage in paragraph 14 of Abortion Services that my learned friend Sir James said gave us the rationale is a passage in which Lord Reid explains that it's about the striking down of the legislation. JR 123 puts this rationale beyond doubt. It's at 6105. And it's at the bottom of the page. There's a heading, the test for a grant of declaration of incompatibility. And
sorry, the page again, please.
6105. So the court in paragraph 88 looks at Christian Institute and explains how Christian Institute had come before the court. And picking it up just below G, the Scottish Parliament is not able to enact legislation which violates convention rights. Where a complaint is made at the time of the enactment that the legislation is outside competence, this is a true ab ante challenge in which it is said that the relevant law must be struck down in its entirety. In such a case, the judgment regarding the validity of the law has to be made looking forward and having regard to the whole range of cases. To strike it down on the basis that it might violate convention rights in some cases but not others would involve a major interference with the legislative competence granted to the Scottish Parliament, since the legislation would be valid in relation to the latter category of cases, and there would be other remedial options available to deal with any incompatibility with convention rights. And so the court then goes on, Sir Declan Morgan and Lord Seales. Accordingly, in Christian Institute, this court stated that the relevant test is that a provision of a devolved legislation can only be said to be beyond legislative competence on the ground that it is a disproportionate interference with a convention right if it would always or almost always have that effect. As is clear, this is a test which supports and gives substance to the legislative competence of the Scottish Parliament. Paragraph 89, McLaughlin, properly understood, was also such a case. Paragraph 90, safe access zones, was also such a case. And that's why the rationale, that's why Lord Seales and Sir Declan explained that that was the test that applied. By contrast, in JR 123 itself, it wasn't a case about devolved legislation. It was a case about an order which had been promulgated before the Northern Ireland Act of 1998. And in that sense, the remedy was a declaration, and that wasn't an ab ante challenge to legislation in the proper sense of that term. So that is the rationale that this court has explained, applies to, gives us that test. And this convention appeal is not a challenge to devolved legislation. It's a challenge to primary legislation. The remedy that the Court of Appeal granted was first of all a declaration of incompatibility, and second, a declaration of that simply stated the breach of convention that we are seeking to uphold. And at this stage of the argument, all we are looking is whether that relief, the simple declaratory relief and the declaration of incompatibility, were correct. What
is there arguably an analogy, because the order made by the Court of Appeal stated that not only that certain provisions of the Act were incompatible with the protocol, but that they were of no force and effect because of Section 7A.
Yes.
So the analogy might be said to be that the court is depriving legislation passed by Parliament of legal force and effect. As a general proposition, in advance of the application of the legislation in any particular case.
Yes. Can I answer that point squarely? Here, I'm addressing the convention. My learned friend, Mr. Larkin, will address Section 7A. Here, we're looking at the test for incompatibility under the Human Rights Act. And the remedy which the court granted was a declaration of incompatibility and the simple declaratory relief. What it then went on to do is applying a different statutory provision, Section 7A, is then it applied that in the Charter and EU law context. But here, all I'm arguing about is the test under the Convention.
I see. So we're going to come on later to the implications, effectively the factor tame implications.
Yes, and we'll look at this application at the end of our submissions. But my learned friend Sir James was seeking to suggest that there was some constitutional issue with even granting a declaration of incompatibility or the simple declaratory relief that the Court of Appeal said. And neither of those types of relief represent an interference with Parliament's legislative competence. Neither of them strikes down the legislation. Neither of them obliges Parliament to do anything. As this court reminded us in Steinfeld and Nicholson's cases, by sending the message to Parliament that a particular provision is incompatible with the Convention, the courts do not usurp the role of Parliament, much less offend the separation of powers. It's open to Parliament to do nothing when faced with a declaration of incompatibility. And so that second justification for the highly deferential test in JR 123 doesn't arise for those reasons. All the court is doing in approving that relief is playing the constitutional role that Parliament gave it in Section 4 of the Human Rights Act. My Lords, I'm conscious of the time.
Yes, if that's a convenient moment, we'll adjourn and resume at 2 o'clock.
Thank you, my Lord.